President. The executive power of the Indian Union is vested in the President. He exercises this power either directly or through officers subordinated to him in accordance with the Constitution. The President is the head of the state and the supreme commander of the Defence Forces of India. The President exercises his powers on the advice of the Prime Minister and the Council of Ministers. The Constitution provides that there shall be a Council of Ministers with the Prime Minister at the head. According to the 42nd Amendment Act, it is necessary for the President to exercise his or her functions in accordance with the advice of the Council of Ministers. Election of the President. The people directly elect members of the Lok Sabha, the Rajya Sabha. Elected members of the Rajya Sabha elect the President. People directly elect members of the state legislative assemblies, and the elected members of the state legislative assemblies elect the President. Thus, the people indirectly elect the President. Qualifications for election. 1. A person shall be eligible for election as President if he A. is a citizen of India, B. has completed the age of 35 years, and C. is qualified for election as a member of the Lok Sabha. 2. A person shall not be eligible for election as President if he holds any office of profit under the Government of India or government of any state or under any local or other authority subject to the control of any of the said governments. However, a person is not deemed to hold an office of profit by reason only that he is President or Vice President or a Minister either for the Union or for any state. A person who holds or who has held office as President shall be eligible for re-election to that office subject to other provisions of the Constitution. Composition of the Electoral College. The President is elected indirectly by the members of an electoral college consisting of 1. The elected members of both Houses of Parliament, 2. The elected members of the legislative assemblies of the states, including National Capital Territory of Delhi and the Union Territory of Puducherry. Nominated members of either House of Parliament and state assemblies are not eligible to be included in the Electoral College. Composition of the Electoral College. A presidential candidate will have to be proposed by 50 members of the Electoral College, MPs or MLAs, and seconded by another 50 members. Earlier, the requirement was 10 proposers and 10 seconders. This was increased by an ordinance promulgated in June 1997 that became an Act of Parliament on August 29, 1997. The ordinance also raised the security deposit of a candidate for the presidential election from Rs 2,500 to Rs 15,000. The election of the President is held in accordance with the system of proportional representation by means of the single transferable vote, and the voting of such election is by secret ballot. Manner of election. Reason for indirect election. 1. If the President was to be elected directly by the people, he could become a rival centre of power to the Council of Ministers. This would be against the parliamentary system with ministerial responsibility. As Jawaharlal Nehru said in the Constituent Assembly, we could not have a directly elected President and not give him real powers. 2. Since the membership in the two Houses of Parliament was likely to be dominated by one party, election of the President merely by a majority of members of the Union Parliament could make him a nominee of the ruling party like the Prime Minister. Such a President could not represent the constituent states of the Union. 3. The President is elected by an electoral college. In India, the Electoral College consists of the elected members of the two houses of parliament and legislative assemblies of the states. Article 54. Such an electoral college would make the president the elected representative of the whole nation with a clear voice given to the states as well. Oath, term, and vacation of office. Oath of office. Before entering upon his office, the President takes an oath in the presence of the Chief Justice of India, or in his absence, the senior-most judge of the Supreme Court, to 1. Discharge the functions of the President of India. 2. Preserve, protect, and defend the Constitution and the law. And 3. Devote himself to the service and well-being of the people of India. Term of office. The President shall hold office for a term of 5 years from the date on which he enters upon his office. He shall continue to hold office, notwithstanding the expiry of his term, until his successor takes charge. Vacation of office. 1. The President may submit his resignation letter to the Vice President in order to resign his office. Such resignation will be communicated by the Vice President to the Speaker of the Lok Sabha. 2. The President may, for the violation of the Constitution, be removed from the office by the process of impeachment. Procedure for impeachment of the President. When a President is to be impeached for violation of the Constitution, either House of Parliament can level the charge as follows. A. Resolution which is moved after at least 14 days' notice in writing, signed by not less than 1/4 of the total number of members of the House. And B. The resolution is passed by a majority of not less than 2/3 of the total membership of the House. 2. When a charge has been so preferred by either House of Parliament, the other House will investigate the charge and the President has the right to appear and to be represented at such an investigation. 3. If, as a result of the investigation, a resolution is passed by a majority of not less than 2/3 of the total membership of the House, by which the charge was investigated, declaring that the charge has been sustained, such a resolution will have the effect of removing the President from his office. Powers of the President of India. Executive powers. The executive powers of the President include 1. Head of the Union Administration. All executive orders are issued in the name of the President. All the Union officials are his subordinates. 2. Appointment of officials of the state. The President makes appointments to key posts to run the government's administration. He appoints A. The Prime Minister and the Council of Ministers on the Prime Minister's advice. He summons the leader of the majority group in the Parliament and asks him to form the government. B. The Chief Justice and the judges of the Supreme Court and the High Courts. C. The governors of the states. D. The lieutenant governors and the chief commissioners of the Union territories. E. The Attorney General of India. F. The Comptroller and Auditor General of India. G. The Chairman and members of the Union Public Service Commission. H. The Chairman and members of the Planning Commission. I. The Chairman and members of the Economic Commission whenever appointed. 3. Control over state governments. The Union government may give necessary directions to a state. During President's rule, the control of the Union government over states is complete. 4. Union territories and border areas. The administration of the Union territories and the border areas is the responsibility of the President. Legislative powers. 1. addresses sessions of Parliament. The President addresses both Houses of Parliament assembled together for the first session after every general election to the Lok Sabha and at the commencement of the first session of each year. In this address, he lays emphasis on the internal and external policies of the government. The President has the power to address either House of Parliament or their joint sitting at any time. 2. Messages to Parliament. He has the power to send messages to either House of Parliament, either in the regard to any pending bill or to any other matter. 3. Summon and prorogue the Houses. The President has the power to summon and prorogue the Houses of Parliament. The power to summon Parliament is subject to the condition that there should not be a gap of more than 6 months between 2 sessions of each House. Normally, there are 3 sessions of Parliament each year, that is, the budget session, February to May, the monsoon session, July to September, and the winter session, November to December. 4. Dissolve the Lok Sabha. He can dissolve the Lok Sabha and order fresh elections. Rajya Sabha is a permanent body, not subject to dissolution. 5. Nomination of members. The President nominates 12 members to the Rajya Sabha from among persons having special knowledge or practical experience in these matters like literature, science, art, and social service. The President may nominate 2 members of the Anglo-Indian community to the Lok Sabha if he feels that the community is not adequately represented in the House. 6. Assent to bills. No bill can become a law without the assent and the signature of the President. Once a bill is passed by both the Houses, it is sent to the President for his approval. The President may give his assent, or withhold the bill, or send it back to the House concerned with recommendations. However, if the bill is passed again in the same form, he has to give his assent to the bill. Usually, the Houses examine the recommendations of the President. 7. Promulgate ordinances. Under Article 123, the President can promulgate an ordinance which has the same status as an Act of Parliament. The President may withdraw the ordinance at any time. The power to promulgate an ordinance is subject to the following conditions. A. The President must be satisfied that circumstances make it necessary for him to take immediate action. B. An ordinance can be promulgated at a time when both Houses of Parliament are not in session. However, if one House is in session, there is no bar in issuing of ordinances. C. The ordinance so promulgated should be laid before both Houses of Parliament when they reassemble. If the Parliament does not approve the ordinance, it lapses. If an ordinance is not disapproved, it will automatically cease to operate at the end of 6 weeks from the date the Parliament reassembles. D. The ordinance lapses if it is replaced by an Act of Parliament. 8. Assent to some state bills. The Governor may reserve some bills passed by the state legislature for the consideration of the President. The President can refuse his assent to such a bill, or he can also send it back for reconsideration. Bills affecting matters such as the powers of the High Court are reserved for the consideration of the President. 9. Formation of new states. A bill for the formation of new states or alteration of areas of the existing states cannot be introduced except on the President's recommendation. Financial powers. 1. Money bill can be introduced only on the recommendation of the President. 2. The annual budget contains the estimates of income and expenditure of the Union government for the coming year. The Finance Minister, on behalf of the President, places the annual budget before Parliament. 3. The annual financial statement is also laid before the Parliament in the beginning of every financial year on behalf of the President. 4. The President can authorize withdrawal of advances from the Contingency Fund of India to meet unforeseen expenditure. Such expenditure should be subsequently approved by Parliament. 5. After every 5 years, the President appoints a Finance Commission comprising a chairman and 4 other members. The Commission makes recommendations to the President on financial matters. Military powers. 1. Judicial powers. 1. The President is not answerable before any court of law for the exercise of the powers and duties of his office. 2. No criminal suit can be initiated against him during his tenure of office. 3. The President has the power to grant pardons, reprieves, respites or remissions of punishment, or to suspend, remit or commute the sentence of any person convicted for an offence. A. In all cases where the punishment or sentence is by a court-martial. B. In all cases where the punishment or sentence is for an offence against any law relating to union and concurrent lists. And C. In all cases where there is a death sentence. Discretionary powers. The President of India enjoys certain discretionary powers. There are certain grey areas where President may have to use his wisdom and judgment. These are 1. Appointment of the Prime Minister in a situation where no single party commands the clear support of the majority of the Lok Sabha members and there is a hung parliament. This is because the President cannot appoint the new Prime Minister on the advice of the outgoing Prime Minister, who may have lost the election or the support of the House. 2. Appointment of a Prime Minister in case of sudden death. For example, by assassination, as in the case of Mrs. Indira Gandhi, of the incumbent, where the ruling legislature party is unable to meet immediately to elect a leader. 3. When the ruling party who has lost majority support in the Lok Sabha, or when a vote of no confidence may have been passed against it, recommends to the President to dissolve the Lok Sabha, then it is at the discretion of the President to either dissolve the House or ask another party to prove its majority on the floor of the House. 4. The President can dismiss ministers in case the Council of Ministers loses the confidence of the House but refuses to resign. Emergency powers. An emergency is a sudden or unforeseen situation demanding immediate action. It is a situation in which the head of state assumes extraordinary powers. So here, the President can proclaim a state of emergency in the following cases. A. National or general emergency. There is a danger of foreign aggression or danger to the peace and security of the country because of a civil war, insurgency, or any other such cause, according to Article 352. B. Breakdown of constitutional machinery. The constitutional machinery in a state has broken down, or there is a deadlock because of political uncertainties or otherwise. Article 356. C. Financial emergency. A setback to the financial stability or credit feasibility of the country is likely to occur or has occurred. Article 360. First, national or general emergency. Circumstances. If the President is satisfied that a grave emergency exists, whereby the security of India or any part of its territory is threatened, either by war or by external aggression or armed rebellion, he may proclaim an emergency. The President cannot issue such a proclamation unless he has the approval in writing of the Union Cabinet. Duration. Every proclamation of emergency must be approved by both the Houses of Parliament within 1 month by a special majority. That is, by a majority of the total membership of the House and a majority of not less than 2/3 of the members present and voting. It cannot remain in operation for more than 6 months at a time. At the end of 6 months, it has to be renewed by Parliament by a special majority, else it lapses. If the Lok Sabha passes a resolution disapproving the emergency, The President has to revoke the proclamation. Effects of general emergency. 1. Fundamental right. The most important effect of a general emergency is that the exercise of the fundamental rights is partially or wholly suspended. Even the right to move Supreme Court or a state high court for the enforcement of the rights, except Article 20 and 21, remains suspended. Article 20 states that no person shall be punished for the same offence more than one. Article 21 declares that no person shall be deprived of his life or personal liberty except according to procedure established by law. 2. Center-state relationship. The country has to forego its federal spirit as the states are obliged to carry out the instructions of the centre. The Union Parliament acquires the powers to give directions to a state on any matter so that the state government will be under the complete control of the Union Executive and will function as under a unitary system with local subdivisions. 3. Finances. The centre is empowered to dispense the financial provisions of the Constitution. Matters such as the distribution of revenues between the centre and the states and the salaries of MPs may be altered. 4. Union and state legislatures. During emergency, the term of the Lok Sabha may be extended for a period of 1 year at a time. The same rule may be applied to the Legislative Assembly or any state. Examples. National emergency was declared for the first time on October 26, 1962. Do you know why this was? Well, this was due to the threat caused by the Chinese aggression on our northeast border. The President revoked the proclamation on January 10, 1968. The second national emergency was proclaimed on December 3, 1971, when Pakistan launched an attack on India. Second, breakdown of constitutional machinery. Circumstances. If the President, on receipt of a report from the Governor or otherwise, is satisfied that the governance of a state cannot be carried on in accordance with the provisions of the Constitution, he may declare an emergency in the state. This is called President's Rule because the President may assume to himself all or any of the functions of the government of the state. Duration. The duration of such an emergency is 2 months. If it were to continue beyond 2 months, it should be ratified by the Parliament. The proclamation will cease to be valid for 6 months after the date of its issue, even if the Parliament ratifies it. It can, however, be extended for another 6 months. Thus, President's rule can normally continue only for a year. It may be extended beyond 1 year under 2 conditions. What are they? Well, A. When a proclamation of emergency is in operation in the whole of India or in any part of the state, and B. The Election Commission certifies that holding elections to the Legislative Assembly of the state is difficult. However, no such proclamation shall remain in force for more than 3 years. Effects of emergency in a state. 1. The state administration is directly placed under the President, that is, the Union government. The governor of the concerned state acts in accordance with the instructions that are issued by the Union government from time to time. 2. The President may, first, dissolve the Vidhan Sabha of the state and dismiss the Council of Ministers, or second, keep the Assembly and the Council of Ministers in suspended animation. In both cases, the Union Parliament can pass laws even on all the subjects of the state list for that particular state. Even the annual budget of that state is presented to and passed by the Parliament. 3. When the Lok Sabha is not in session, the President may authorize expenditure out of the consolidated fund of the state. 4. The President may suspend the provision of the Constitution relating to any authority of the state except those relating to High Court. Examples. This form of emergency is quite common in India, and President's rule has been imposed in a state at one time or the other. The first instance of the president's rule was in 1951 in Punjab. In 1977, 9 states were brought under the president's rule on the pretext that the state assemblies no longer reflected the views of the people. In December 1992, president's rule was imposed on Uttar Pradesh, Madhya Pradesh, Rajasthan, and Himachal Pradesh. On October 21, 1997, the Union Cabinet recommended the imposition of President's rule in Uttar Pradesh following acts of violence in the Vidhan Sabha. The President felt that acts of violence did not imply breakdown of constitutional machinery, so he returned the recommendation for proclamation of President's rule for reconsideration. In 2013, President's rule was imposed in Jharkhand from January 28, 2013 to July 12, 2013. This was because BJP's ruling coalition partner JMM, that is Jharkhand Mukti Morcha, withdrew its support to the government, pushing it into a minority. Chief Minister Arjun Munda resigned and sought dissolution of the State Assembly. Third, financial emergency. Circumstances. If the President is satisfied that a situation has arisen whereby the financial stability or credit of the nation is threatened, he can declare a financial emergency. Duration. Such a proclamation has to be laid before both Houses of Parliament and is valid for 2 months unless it is approved by resolutions of both Houses of Parliament. If the Lok Sabha is dissolved when such a proclamation is made and a resolution supporting it is passed by the Rajya Sabha, the proclamation will cease to exist at the expiry of 30 days from the date on which the Lok Sabha first sits after its reconstitution. Effect of financial emergency. 1. The President may appoint a finance commission to suggest methods to get out of the financial crisis. He may adopt suitable measures to restore financial stability in the light of recommendations of the Finance Commission. 2. The President can reduce the salaries and allowances of all or any class of persons, including the judges of the Supreme Court and the High Court. 3. All money bills passed by the Lok Sabha are to be submitted to the President for his or her consideration. 4. The President can issue instructions to the states in regard to the utilization of funds in the manner he thinks fit. 5. The President may order the state to submit money bills to him for his assent. Financial emergency has never been declared since the promulgation of the Constitution. Vice President. Article 63 stipulates that there shall be a Vice President of India. Qualifications for election. 1. A person shall be eligible for election as Vice President if he, A, is a citizen of India, B, has completed the age of 35 years, and C, is qualified for election as a member of the Council of State. 2. A person shall not be eligible for election as Vice President if he holds any office of profit under the Government of India or government of any state or under any local or other authority subject to the control of any of the said government. Election. An electoral college consisting of the members of both Houses of Parliament elects the Vice President. The election is held in accordance with the system of proportional representation by means of the single transferable vote. The voting at such an election is by secret ballot. Each nomination paper should be proposed by at least 20 electors, that is MPs, and another 20 electors should second the same. Earlier, the requirement was 5 proposers and 5 seconders. Oath and term of office. Oath of office. Before entering upon his office, the Vice President takes an oath before the President or some person appointed on his behalf by him to A. Bear true faith and allegiance to Constitution of India and B. Faithfully discharge his duties. Term of office. 1. The Vice President shall hold office for a term of 5 years from the date on which he enters upon his office. 2. He may, by writing, addressed to the President, resign his office. Such resignation will be communicated by the President to the Speaker of the Lok Sabha. 3. He may, for the violation of the Constitution, be removed from the office by the process of impeachment. 4. He shall continue to hold office notwithstanding the expiry of his term until his successor enters upon his office. Powers and functions. 1. Chairman of the Rajya Sabha. The Vice President of the Indian Union acts as the ex officio chairman of the Rajya Sabha. In this capacity, he regulates debates and proceedings of the House and decides the order of speeches. He decides the admissibility of a resolution or of questions. He may suspend or adjourn the business of the House in case of grave disorder. He issues directions to the chairmen of various committees in all matters relating to their working. The Vice President gets no salary as the Vice President. Whatever is paid to him is only in the capacity of the chairman of the Rajya Sabha. In his absence, the Deputy Chairman, who is elected by the members of the Rajya Sabha, heads the Rajya Sabha. 2. Taking over as the President. The Vice President takes over the office of the President under the following situations. A. Death of the President. B. Resignation of the President. C. Removal of the President. Or D. When the President is unable to discharge his functions owing to absence, illness, or any other cause. In the event of the President's death, resignation, or removal, the Vice President acts as President and enters upon his office until a new President is elected. This is unlike the Vice President of the USA, who becomes the President for the remaining term of the office.